there are two important things which the governor has not taken into account, which to my mind were extremely important. One, that insofar as the Congress and the NCP are concerned, there is absolutely no shaking up of there is no internal dissension in either the Congress or the NCP. Congress had 44 members, NCP had 53 members. This is a block of 97. There's absolutely no dissension in either Congress or the NCP. So in the 97 still continues to be a solid block. What is disturbed is, say, out of the 56 that the Shiv Sena had, 34 have expressed
which brings it down to your lordship, sir.
So out of the second thing which the governor had to bear in mind is this, that as of this date, there is not even a suggestion that the Shiv Sena is going to team up with the BJP to form the government. So that's again a circumstance which is totally alien to his consideration. So he can't be oblivious of the fact that in a three-party coalition, the dissension has taken in one party out of the three. The other two are steadfastly support the coalition, and they are not by any means, sidekicks. They are almost at par. All the three are virtually at par, except the Congress, which was a little lower.
May I only make one request? To examine the facts of the case, after, my lord, I show the law, your lordships have shown, but some of the paragraphs, some of the law is unfortunately, my lord, not assisted.
2006.
Thereafter also, my lord, why the governor can take that step, even if NCP Congress block is not disturbed. 482, my lord, para 85. I am reading 85, 161, 164 and 165, which is on this point, my lord. And my lord, kindly bear one factor in mind. My lord, whether the court would have taken the same view which the governor took may not be the test while determining, my lord, the decision taken by the governor. Court may perhaps on the facts arrive at a different conclusion. Yes.
The stark distinction so far as Rameshwar is concerned, Rameshwar government was not formed. It was at the initial stage immediately after elections.
Correct.
Where there was no party who got the majority. Instead of waiting for somebody to form a majority, the governor asked for dissolution of the House.
356.
And the reason he has given is that if I spend more time to allow a coalition to be formed, they will cobble up a majority and thereby violate 10th schedule and then create a government. So court said the governor cannot assume that one of the political parties would go ahead, cobble up majority by coalition. This is a wrong inference that the governor has drawn. But as against Rameshwar Prasad's case, this is a case where the government is subsisting for more than 3.5 years. So that's the distinction between Rameshwar and ours. I'm just putting it to you.
Facts, yes, but the legal proposition which I would, my lord, place for your lordship's consideration may be the same. The consequence which would, the power of the governor or the exercise of power of the governor at the time of initial formation or subsequent shall have to be the same. That's my respectful submission. Because I, my lord, with profound respect, do not see any reason to not read this ratio for exercise of power under 174 and 175 also. This was also the case where the Supreme Court said you should have called for the floor test. You could not have said that, no, they might incur disqualification. My lord, your lordships are right. My lord Justice Narasimha are right. Fact situation was 356. But why, my lord, I'm posing a question to myself. This ratio not apply when the governor decides to call for a floor test, which your lordship said is the only test. My lord, what fell from, my lord, the Chief Justice would be, my lord, if I put it in the context of this ratio, would be that the governor will have to first form an opinion that these people are working since 3 years. They have shown the reason to the governor why they are parting ways after 3 years. But can they do it after 3 years? Would it not amount to a split? Would it not amount to disqualification under Chapter 10, Schedule 10? Lord, he also cannot refuse floor test.
But look at what the consequence of these observations in the present cases. The governor,
I earnestly request your Lordship.
but we are since beyond those two paras, just those two paras. No such, the court says, the governor cannot refuse the formation of the government and override the majority because of his subjective assessment that the majority was cobbled by illegal and unethical means. Therefore, irrespective of what the governor feels or what somebody else feels about, the fact that in forming a government with the INC and the NCP, you gave up a pre-poll alliance, it is irrelevant to the governor. This is a government which has been legitimately formed. All right, that's step one. Second, para 166 says that the governor cannot assume to himself the aforesaid judicial power and based on that assumption come to the conclusion that there be a violation of the 10th schedule. So it was alien to the governor's mind that these 34 would have to be excluded from consideration because they have incurred a disqualification under the 10th schedule. For the governor, he has to treat these as part of the Shiv Sena, irrespective of what their internal dissension is. Therefore, he cannot now say that this 34, the letter which these 34 have given me, is a ground for shaking the faith of the government or the trust of the government which they have. He has to take these 34 as forming a part of the Shiv Sena legislature party.
Now let me show.
And if they are a part of the Shiv Sena legislature party, where is there any ground to say that, well, there is now a change in the position of trust in the house? Prima facie, at least, for him.
Now, my Lord, let me show the judgment of the High Court, which was dealt with by Bomai judgment. Your Lordship's, my Lord, very right concern, Lord, comes in the form of Mr. Sorabji's arguments, which was rejected, and your Lordship in Bomai did not accept that rejection. A special bench of 3 judges of High Court heard the writ petition and dismissed the same on the following reasoning. Please come to 6, my Lord. The introduction of 10th schedule of the Constitution has not affected in any manner the content of power under Article 356. Lord, the argument of Mr. Sorabji was that, all right, why you are not concerned with 10th schedule. Direct floor test to be held. Don't dismiss the government under 356 straightway. And, my Lord, the court, my Lord, thereafter, Lord, 397, in this context, my Lord, the court examined this, my Lord, that it is wrong. The governor should consider before removing the ministry, before not installing the government and imposing precedence rule, you should have given the floor test. The request was that give me floor test. Don't impose precedence rule. Let the 10th schedule play its role. If somebody votes against the will of the party, he will be disqualified. But don't take extreme step of 156. Take step under 174 and 175. That's what precisely the governor has done. Where all this is considered. But before that, please come to para 7 of my propositions. Why, my Lord, this cannot be the argument of the petitioner, and I'll demonstrate, my Lord, what is the flip side of this argument. If your Lordship, my Lord, were to hold that governor cannot examine the inter se dispute, or he waits till the speaker decides disqualification, what is the flip side? I must, my Lord, assist your Lordship with that flip side. My Lord, disqualification is not automatic. If I, as a member of legislative assembly of a particular party, vote in defiance of the whip, so there is a provision that the party may condone it within 15 days. So governor cannot say that I'll wait for 15 days when he is presented with the facts that this is the dissatisfaction. The government has lost majority. There are attacks taking place. There is vandalism taking place. Threats being administered. Then I'll not wait for 15 days. Because
Mr. Solicitor, there are two
examining propositions.
Right, there are two distinct things. One is a dissatisfaction within a party, right? And the other is the loss of majority of the government. One is not necessarily indicative of the other.
Correct.
Now tell us, in this situation which we had over here, we now put ourselves in the shoes of the governor. What was it that would have led the governor to come to the conclusion that the government had lost the majority? What was the factual basis for him to conclude?
Again, Only, my lord, one thing. My lord, kindly bear one.
Only one 34.
Who were part of the government, who were supposed to be having confidence of the chief minister.
Right. So what
Second,
therefore now let's go to the bottom of it.
Look, can I first take the lordships to the bottom?
What is the governor saying? What is the governor saying? These 34 who are part of the Shiv Sena have now expressed their dissatisfaction with the leadership of the Shiv Sena. Unless the governor says that the natural corollary is that these 34 will cease to support the Shiv Sena.
I'm sorry.
We will make every assumption in favor of the governor's decision. Because that's how we test the proposition. What could the governor have said, though he doesn't say that these 34 persons who are part of the alliance between the Sena, the Congress and the NCP have now expressed their dissatisfaction. He can call for a floor test if he has any circumstances before him to indicate that the strength of this three-party coalition has been substantially reduced. The Boma is absolutely correct, it binds us anyway, that this disqualification issue under the 10th schedule is completely irrelevant. But what is the consequence? The governor has to treat these as continuing members of the Shiv Sena. Even before us, they are not saying that we have ceased to be members of Shiv Sena.
Yes.
Now, if they continue to be members of the Shiv Sena, and the Shiv Sena therefore continues to have 55 or 56 members, which it originally had.
If they vote against, they will incur disqualification. Governor would say that.
Right. But then where is the question? What is the reason for calling a trust vote?
Because they said
the
that.
Governor, all our judgments say, Rameshwar Prasad says that, Bomai says that the 10th schedule disqualification is irrelevant to the exercise of judgment by the government.
I'm obeyed.
That authority goes to the speaker. Therefore, the facts as they stand before the governor indicate that these 34 are part of the group of 56 Shiv Sena MLAs. Now, if that is so, on what cogent material does the governor call for a floor test? What has changed for him to call for a floor test?
Difficulty is,
tell us one reason why he has to call for a floor test then.
My lord, your lordships are again on facts, my lord. I am on propositions first. And then, my lord, I'll try and fit into the propositions to the facts of the case. Number one. Number two.
Principally, forget the facts. Forget the facts.
Principally.
Forget the facts.
What?
The governor, as a matter of principle now, Bomai tells us and Rameshwar Prasad tells us that circumstances which would lead to the which would warrant the invocation of the 10th schedule are alien to the mind of the governor when he calls for a floor test.
Correct.
All right. So, therefore, the possibility that these 34 in our case would incur a disqualification is irrelevant to the exercise of power by the governor.
I bow down, my lords.
Right? Now, if that is so, then the governor must forget the facts of this case, the prime principle. The governor must proceed on the basis of the position as it obtains. When the government has been formed, there is nothing which has, unless there is something, some subsequent event which alters the legal constitution of the government, the governor must continue to have before him and analyze the situation on the basis of the situation as it was when the government was formed and prior to the 21st of June in our case. He can't go into the 10th schedule, that's the speaker's jurisdiction. If he can't go into the speaker's jurisdiction, which is the 10th schedule, then what is the basis for calling a floor test? The only reason why he could have called for a floor test is that these 34 numbers, these 34 have alienated themselves. They have given up. They say that we have lost faith in Uddhav Thackeray, and therefore these 34 are excluded, the numbers.
Your lordships were pleased to record, my lord, several past cases where the governor either decided to direct floor test, parties came here and your lordships did not intervene, or governor was not directing floor test, parties came here and when required sitting at midnight, your lordship directed that immediate floor test, and the only purpose was that there is no time for either pressure, threat, coercion, violence, allurement, etc., etc. Whatever is the will should be reflected at the first available opportunity. Therefore, your lordships will not set at night in case of Karnataka. There are several such instances. So therefore, I was saying that you should not only command the majority support at the time of formation of the government, you must continue to command that. That's the democracy. So it is only in extraordinary circumstances that there would be a departure from floor test rule. Otherwise, floor test is the rule. So that's what, my lord, the test your lordships were pleased to lay down. Because when we say, my lord, that defection is the highest political sin, Lord, running a government after losing the confidence of the electorate, namely the House, is a larger constitutional sin to which governor should not be a party. Continuous existence of that trust gives you the legitimacy in democracy.